Hi, my name is Warren Surface, and I'm reporting on Miller versus California. This case involves a man named Marvin Miller. Miller worked for a lewd, aka sexual company. He decided to launch a mass marketing of his material that portrayed men and women with their sexual genitalia predominantly displayed throughout the advertisement. He dispersed these throughout local California neighborhoods regardless of whether or not the resident requested this material. Upon receiving this advertisement, a mother and child were so offended they filed a complaint to the California Police Department. Miller was later arrested on the grounds that the, quote, information was unsuitable for the general population, unquote. Miller appealed his arrest and the fact that his material was, quote, obscene, unquote, claiming that the arrest was in violation of his First Amendment. The trial took place on January 19th, 1972, and was decided on June 21st, 1973. This was a burger court case. Marvin Miller was found guilty of a misdemeanor because the material was deemed unsuitable for the general population. The Supreme Court ruled that Miller's First Amendment rights did not apply because his material was not suitable for the general public. The court also ruled that as an American we are allowed to have the right to the First Amendment. However, these rights are not given to American citizens if they are putting the general public in any sort of harm's way with their speech, assembly, religion, press, or petition. Before you ask, yes, Kirby, this is why you cannot assemble and start a riot of Kirby's or start a fight club legally in America. The ruling of the Supreme Court also formulated the Miller test for obscenity. It sets the following criteria. 1. Whether the average person applying contemporary community standards would find the work, quote, taken as a whole, unquote, appeals to prudent interest. 2. Whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. 3. Whether the work, quote, taken as a whole, unquote, lacks serious literary, artistic, political, or scientific value. This ruling upheld the 1957 ruling on Roth versus the United States, a Warren court ruling. Despite the guidelines that the court produced, however, the Supreme Court ultimately decided that determining what exactly was, quote, obscene, unquote, should be left up to a state to decide. This was due to the fact that they believe it was impossible to develop a national obscenity standard because of all of the varieties of different communities.